All right. The Court of Appeal and for the 6th District of the State of Florida is now in session. The Honorable John K. Starkville, Judge presiding. All persons having been before the court draw near to the attention of the heard. And God save the United States of America, the state of Florida, and then honorable court. Please be seated.
Good morning. I'm Judge John Starkville. As Marshall said, I will be presiding today. I ask everyone to please make sure your cell phones are turned off, or at least in stun mode, so that only you get the vibrating. Joining me today on my far right is Judge Cohen, who is going to be joining us for just a little while longer. He's been asked to introduce.
And that's what happens.
Exactly. So, this is my last opportunity to get to sit on a co-lead panel with you. And do this if I didn't just tell you how interesting it's been this past year starting a new court and having you and your team. Sense of humor and your experience to help us get going. I really do appreciate it.
Thank you, Judge Stark.
Judge White, joining us here, both of them are from Orange County.
I concur with your sentiment.
So,
If that were really true, they wouldn't have voted me off the court, so.
that was the island. We voted you off the island.
Oh, okay.
Okay, well, you have a couple cases before us today. And first one is Andrew Brian Sheets versus the state of Florida. And That you recognize?
Good morning, Your Honor.
You can, 20 minutes. How much would you like to?
I'd like to reserve 5 minutes for appeal, for rebuttal, please, Your Honor. May it please the court?
You recognize?
Your Honor, before the court is Andrew Sheets versus State, 60-23-577. My name is Christopher Cosden. I represent Mr. Sheets, who is the appellant here. He was the defendant below. This case arose on July 22nd of 2021 when Mr. Sheets...
We're familiar with the facts of the case.
Sir?
We're familiar with the facts of the case. We actually do read the briefs and the record. So let's just address the legal issues, if you wouldn't mind.
Your Honor, this case raises two important sets of issues. The first has to do with sufficiency of the evidence. Mr. Sheets was charged with breach of the peace, and he was convicted of that, and with disruption of a school function. There was not sufficient evidence to prove either of those to the extent that the case should have gone to the jury. To prove the crime of breach of the peace, the state must prove that the defendant committed an act or acts that were of a nature that corrupted the public morals, outraged the sense of public decency, or affected the peace of quiet of persons who witnessed the acts. Now, the Florida Supreme Court interpreted that in State v. Saunders, where the Supreme Court held, we now limit the application of section 877.03 so that it shall hereafter only apply either to words which by their very utterance inflict injury or tend to incite an immediate breach of the peace. The court went on to say, we construe the statute so that no words except, quote, fighting words, end quote, or words like shouts of fire in a crowded theater fall within its prescription in order to avoid the constitutional problem of overbreadth. Section 877.03 should not be read to prescribe the use of language in any fashion whatsoever. Well, what we are lacking here is proper words. There were certainly no words which, if spoken, would be inherently dangerous, nor were there words that incited anyone to a breach of the peace. The police officer...
You don't think that parents at an elementary school where there's a man there and he's got obscenities and he's got pictures on his shirt of aborted fetuses, that isn't going to outrage and spark action by parents who want to protect children of such a tender age?
That certainly could happen. However, here there's no evidence that it did. None of the parents testified. The only people who testified about the actions of the defendant were the police officer I just mentioned and an administrator from the school. The administrator from the school had nothing to say of any import about what Mr. Sheets actually said. The police officer testified that he believed that the words were not directed at him, and he was certainly not incited to fight. None of the parents testified. We do not know what the parents thought because there was no evidence to tell us what the parents thought.
Wasn't there a video?
There was a video.
And didn't the video show a parent that confronted him and he had the bullhorn and so we do have that evidence as to how parents, at least that parent, reacted.
One set of parents, or at least one parent, we don't know who the male companion was, But one parent apparently returned after dropping off a child with a bullhorn and a siren. She set off the bullhorn, she set off the siren. There was no direct confrontation between that parent and Mr. Sheets. We see that very clearly on the video recording. The
council couldn't have confrontation inferred by the fact that the client was essentially looked like that tree base of the altercation across the street.
Okay, the altercation across the street apparently occurred when a police officer drove up in a car and directly confronted.
Not on that, I'm talking about the confrontation with the parent Judge Cohen refers to. Doesn't the video depict that confrontation occurring very, very close to the entrance on one side of the street? And couldn't it be inferred from that video that the level of animosity was so great that their client retreated across the street?
We don't know why Mr. Sheets retreated across the street.
It's the expression of the parent.
Yes, the parent was obviously.
Friendly expression.
The parent was obviously annoyed. Well, the fact that the parent did that told us the parent was annoyed. But counter protests are not something that is unusual or even too surprising. We often see one person or one group of people protesting in public and other people protesting for the other side of whatever the issue is.
Now, he was calling people Nazis and using a phrase that, what's the baseball movie with Costner? Bull Durham, that they said you couldn't call umpires. You don't think that, but you never saw that movie, huh?
No, sir, I
Right.
didn't. I'm
Okay.
sorry.
Yeah, it's all right. I don't want to just as soon not use the phrase, but in any event, calling people Nazis and suggesting that that they engage in fellatio, you don't think that that's sufficient at an elementary school with parents dropping kids off to constitute fighting words?
Your Honor, the law does not recognize a venue. Now, certainly some words are not to be spoken in church. Certainly some words are not should not be spoken in the presence of small children. However, there's no evidence that Mr. Sheets ever went on the school property. There's no evidence that any child ever heard anything that Mr. Sheets said. So
Do you think these parents became outraged because only they were hearing it?
I think the parents became outraged because somebody was protesting in front of the school. And
You don't think it had anything to do with the words that they were saying with their children?
well, perhaps the parents were outraged, but there's no evidence that the outrage extended to being fighting words. There was no fight. There were no fisticuffs by anybody.
You don't have to wait for a fight for words to constitute fighting words. You have any case law that supports that, your proposition that there has to actually be a physical confrontation?
No, Your Honor, there does not need to be a physical confrontation, but the physical confrontation has to be likely. And here, the words that were spoken did not apparently cause anybody to fight or come close to a fight. Nobody got out of their car and approached Mr. Sheets with a raised fist. That could have happened. Had that happened, that evidence would certainly suggest that the words spoken were fighting words. But that didn't happen. So when we have one person only uttering language and no evidence at all that Mr. Sheets intended or caused anybody to approach him in a manner which would suggest that a fight was about to
Well, he'd
start.
been there, a couple days before. He knew exactly what was going to happen when he went there.
One could infer that, but we don't know well, we do know. In fact, that's yet another issue in this case. We know probably too much about what happened on the earlier days, but there's no evidence of any incipient fight on either of the earlier days. But let me address disruption of an educational activity, if I may, please. The second charge in this case was also not proven. There was no evidence at all that any educational activity was disrupted. Now, as we all are perfectly well aware, the function of an elementary school is education, and the model of education is usually classroom instruction.
And
There-
does that mean that the kids actually can get to a classroom and get there on time? Is that part of
Yes,
it?
there
And
was.
and they couldn't do that here.
There was no evidence as to what students were late, how many students were late, or more important, whether there were more students late that day than any other day. The other part of that is there is no evidence at all, not one scintilla of evidence, that any student missed any part of any classroom instruction. Now, the state could put on evidence that that happened if it had happened, but at this point, we don't know that any classroom instruction was missed. Now, let me go on to the second part of this, which the court has already raised in the question, and that is the evidence of prior bad acts. Now, there are two problems with the evidence of prior bad acts. The first one has to do with the notice that was given. Of course, there's a notice that's required in 90.404. Prior to trial, in a motion in limine, counsel for the defendant stated to the court that he had never received the notice. The prosecutor responded with, "Oh, I filed the notice." Well, he certainly did file the notice. It's on page 39 of the record. The question is whether or not it was served. And there was no testimony or no comments from counsel in connection with that motion in limine to exclude the similar bad act evidence that the defendant's attorney ever actually received the notice. He said that he didn't. Nobody said that he did. Now, that alone should resolve the issue. The statute requires the notice, and the notice must be, the statute specifically requires that the notice be provided to the defendant or counsel for the defendant. Okay. The other part of that is that the evidence of prior bad acts was much, much more extensive than the direct evidence.
Did going back to the filing of the notice, did the notice have a certificate of service on it?
It did.
And was the certificate of service to Mr. Sheets' counsel?
It was. The certificate of service is on page 39. The certificate of service says, "I hereby certify that your true and correct copy of the above and foregoing has been furnished to," naming the attorney, "by United States Mail / hand delivery / electronic transmission," and a typed signature. Now, that notice does not comply with the rule. If we look at Rule 2.516, we see, and this is in B1 of 2.516, we see that all documents required or permitted to be served on another party must be served by email, with some exceptions that have no application here. The rule goes on to say the filer of an electronic document must verify that the portal or other e-service system uses the names and email addresses provided by the parties. Well, there is nothing in that certificate of service that so states. The prosecutor, when he served that document, did not state that he served it through the portal. He did not state that he served it by email. He did not state to whom he served it. So
Did he represent that to the trial court?
he represented that he had filed the document. He did not represent that he served it or that opposing counsel had it. His responsibility under the statute and the rule was to ensure either that the trial counsel actually had it or that it had been served in a very specific way required by rule. He did not do that either verbally or in his certificate of service. So if I may reserve the rest of my time for rebuttal, please. Thank you.
Good morning. Blaine Goff on behalf of the appellee of the state of Florida. May it please the court, counsel. First addressing the sufficiency of the evidence when it comes to the breach of the peace charge. As the court has stated, the jury was presented with a video. The video showed probably picked up where the parent dropped out their kid, came back with a bullhorn and confronted Mr. Sheets. Also, it's observed that parents exiting the school onto Naranja Street were engaging with Mr. Sheets in a hostile manner, both engaging back and forth. It showed the shirt, the sign, just his demeanor, and the officer approaching Mr. Sheets, kind of requesting, take your protest somewhere else outside of this school area. The jury was able to hear the resident, Mr. Jewell, who called the police, was awoken from sleeping, and called the police due to the altercation between Mr. Sheets and the other parents. I believe that also shows it wasn't just one parent, it was more than one, and had not the intervention of the officer, it of course could have become a more violent situation. The officer then begins to encourage Mr. Sheets to move, and he is not doing so voluntarily the entire way. You can observe him cursing back at the officer, using the word Nazis and the words that were discussed earlier. This was competent, substantial evidence sufficient for the jury to convict Mr. Sheets of disturbing the peace. In terms of the sufficiency of disrupting a school function, the school resource officer testified that Mr. Sheets was there. I don't believe there was any evidence that he had permission to be there. There was no legitimate business there. He wasn't there, and it was the specific time that he was there during the very chaotic portion of the day in which I believe ages 4 to 11, the kids are being dropped off at school and they're walking into the area where he was standing. Any school walkers were walking there as well. There was testimony from the school administrator that the school dismissal process, the tardy process had to be suspended that day. She had to station another administrator outside the area to make the students feel more safe. They can be seen on the video at some point directing traffic to try to get it to move. I believe the normal dismissal process was the most chaotic on the day that he was charged with, and ended.
It wasn't a dismissal.
I'm sorry, arrival or drop off area. And there was testimony that day was the worst day of the three. Again, the jury was able to see the video. So I believe that was sufficient, competent, substantial evidence to sustain a conviction or survive a judgment of acquittal. Additionally, any of the words that were used, again, State v. Saunders and LJM kind of placed that type of language on top of that. But it was more than that. It was his conduct. It was an overall conduct, but the words do fall into the language of LJM. And his behavior, intent, I believe there was some argument about intent. I just want to address that briefly. Intent is hardly ever or almost never a basis for a judgment of acquittal. I think the jury can infer that from the evidence. I think this behavior is very akin to Meineke, which was recently decided with the sister court, but it was probably more egregious because that was a high school and the language there wasn't foul language or anything like that. It was preaching, and that was enough, similar type evidence enough to sustain a judgment of acquittal. Or moving on to the issue 2, the Williams rule evidence. As I've stated in my brief, the service was in the record. The prosecutor sufficiently represented that he served it properly. Even if it wasn't served properly, I believe the motion in limine was heard by the court, and argument was heard, and the court made the determination that this was sufficiently similar to and relevant towards his lack of mistake, and also a motive and intent, which is a requirement under the statute. So I believe it was relevant. It came in. There was no objection to feature of the trial. There was no motion for mistrial. And I believe the jury instructions adequately demonstrated that there was a special jury instruction before the evidence was read, where they're not to consider this for any other purpose other than what it was used for. And I believe it was used for the purpose that the state intended it to. Again, intent, lack of mistake. If there are no further questions, we rely on our brief, and we would ask that you affirm Mr. Sheets' convictions and sentences. Thank you.
Counsel mentioned engagement by the parents. There is a short, less than 20-second portion of the video recording that shows Mr. Sheets speaking with apparently a parent, some driver of a vehicle that was pulling out of the drop-off area. We presume that was a parent. We don't know that. But there is nothing about that interaction that suggests that there was about to be a fight, or even what Mr. Sheets and the parent were saying to each other. Nobody testified about that. As to the person who was awakened by the bullhorn, there is no question that Mr. Sheets did not have the bullhorn or the siren. The gentleman who lived across the street was in fact awakened by the bullhorn, but that was part of the counter-protest. That was not Mr. Sheets' doing. Counsel mentioned that tardy access was suspended on that day, or the tardy procedure, I guess, was suspended on that day. Well, that's interesting, but it still doesn't tell us whether or not any student was actually late to class, or whether or not any student missed any instruction at all. We also don't know how often, on what other days, or when or if the procedure for dealing with students who were late was suspended. I'm sure none of us has ever been late to school, but we recognize that other people can be late and often are late. Their schools have ways of dealing with that. We don't know from the testimony here how many students were late, or whether it was more or fewer than students on other days. Counsel mentioned his brief, and that presents an interesting question with regard to the similar fact evidence. When counsel wrote his brief, he apparently had had some difficulty distinguishing what was similar fact evidence from what was direct evidence in the discussion of the similar fact evidence. I wrote a reply brief, I'm not going to try to read it, which sets out in great detail which lines and phrases were similar fact evidence that counsel took as direct evidence. Now, that's important, and the reason it's important is if my learned colleague had difficulty distinguishing the similar fact evidence from the direct evidence, then jurors may have had the exact same problem, and it is very, very likely that they did, since the jury, all the jury knew about the law of similar fact evidence was the jury instruction. So, if there are no further questions, I would ask the court to reverse the convictions or the withholds of adjudication on both counts and to remand this case for dismissal. Thank you very much.
Thank you, sir.
Thank you. All right, our next case this morning, Avatar Properties, Inc. versus Norman General. Okay. Well, before we get started, colleagues and I had a discussion this morning, and we figured that you'd all spend at least 8 to 10 hours preparing for this per day over the last ever how many months. But you all don't have to use it, but we feel based on questions and things we have that we're going to increase the time to 30 minutes per side.
Okay.
So let me do that. And I'll let you reserve 5 or a little bit more if you want.
5, Your Honor.
Okay. All right, if you could identify yourself for the board when you're
Yes.
recognized.
Good morning. Joseph Lang from Carlton Fields on behalf of Appellant Avatar Properties, Inc. At council table with me is Dan Fleming, also on the brief with me. A primary question, perhaps the primary question in this appeal, is whether Chapter 720 prohibits the club membership fee that's at issue.
Before you get there, yeah. I know it's no surprise to you that you know, we actually do talk about these cases a little bit before the oral argument. And I think that Judge White has had some questions about jurisdiction and perhaps whether this is a proper final appeal. I'll defer to Judge White to perhaps articulate that question because we should address that preliminarily.
Yes, Your Honor.
Since I can't improve on Judge Cohen's question, why don't you just tell us?
Okay.
Why do we have jurisdiction?
Okay. First and foremost, this is a final judgment. What is left below has been formally severed by order. The remaining counts in the individual claims, there's a formal order of severance. So Ms. Norris and I did not take this haphazardly. We actually discussed it at length, and I know you can't agree to jurisdiction, but we are very confident that this is a final order in that everything else has been severed. So I think first and foremost, it's just a final order under 9.10
9.110, and I think that's the way we should proceed. But I must emphasize, especially in that
Severed or dismissed?
they have been formally severed. There's an order of severance for the remaining counts in the individual claim. So, I mean, there's a formal order of severance.
This case was proceeding under Rule 9.110 sub K, correct? That's mentioned in your briefs. Our predecessor, second DCA, issued an order saying that the case would proceed under that rule. So are you contending that this is a partial final judgment, or are you contending that it's a final judgment that entirely resolves, disposes of an entire case as to any party, or both?
I would contend both, but primarily I would contend this is a final judgment under 9.110 in that everything else has been severed. I believe that that severance also would satisfy 9.110K as a partial final judgment in that that's, severed and independent would be one of the tests you would look at. But I think the fact that the remaining claims are severed altogether gives you jurisdiction as a final judgment. But I need to emphasize, because in case there's any doubt as to jurisdiction, there's a permanent injunction here. And so in all events, there's jurisdiction.
Right, no, we understand that.
Under 9.130.
As to the injunction.
And then most important for my client, of course, is that if for any reason you were to conclude this is not final, there's an executable judgment for $34 million that's been signed. And if we're not able to appeal an executable judgment, I think you can treat the order under certiorari to quash the execution language in the judgment. We can't be in a situation where there's a $34 million executable judgment that's not appealable. I think it's fully appealable. My colleague thinks it's appealable. I know we can't agree to jurisdiction, but nobody's challenging jurisdiction among the parties. But if there's any question as to the appealability of the money judgment, it needs to be quashed until a final judgment could be entered, quashed under your certiorari jurisdiction.
Before you just get going, just one as an aside, on your JM Family Enterprises versus Winter Park Imports, your citation is wrong on that case, just as a, pointing that out to you. It's not, anything that I couldn't figure out quickly, but you should have somebody checking sites on your briefs.
Okay.
Okay, let's go.
Yes. I apologize to the court
Not
for that.
Not a big deal.
The primary question in this case is whether Chapter 720 prohibits the club membership fee that's at issue. So I think a good place to start is what is the purpose of Chapter 720? And the purpose is very, very clearly laid out as being to give statutory recognition to corporations not for profit to operate residential communities in the state, and to provide procedures for operating homeowners associations to protect the rights of the association members without unduly impairing the ability of such associations to perform their functions. It's pretty clear that the purpose of this statute is to create and regulate homeowners associations. So right at the outset, it's important to emphasize that Avatar is not a homeowners association.
There's discussion of developers and the legislature understood how this worked and how it was being passed off. So your position that it's only not for profit, how do you reconcile it?
There is mention at points of developers in there, but the actual purpose of the statute, the plain text of the statute, is to regulate homeowners associations, and we are not a homeowners association. That becomes important when we turn to the substantive sections that are at issue here.
Well, you all certainly did avail yourself of the provisions of 720, didn't you?
In what way, Your Honor?
You don't know?
We have a club plan that is an independent club plan that was recorded even before the master declaration and creates an independent covenant running with the
So
land.
you've got, fees and expenses that are being assessed against the homeowners. Did you not utilize 720 to do that?
No, we don't, that is one of our major.
Yeah. And did you not bring actions and foreclose for those people who did not make those payments?
We did do that, and our right to do that is based on common law covenant running with the land. Now, I acknowledge that there is evidence in this record that Chapter 720 was cited in some of those documents. There's also an affidavit from the attorney.
I know that affidavit is, it's hardly persuasive. Yeah. Scrivener's error on case after case involving, foreclosure and suits on non-payment. I mean, how many times do you make a Scrivener's error before you, before it becomes, kind of transparent that, that's just silly.
But it's unrebutted in the record that it is a Scrivener's error. And just to give some background, I can't testify, obviously, but obviously the same attorney is using systems that also would involve foreclosures for the association. And so, it's form work. It's not excusable. I acknowledge that. And that affidavit indicates.
He referred to 720.
He did, but there's unrebutted evidence that it's a Scrivener's error, and that should at least be a factual issue, one would think. But yes.
Moving on, so opposing counsel that read in their complaint and continuing that, in essence, this, I don't call it scheme in a bad way, but that you presented here would allow you to actually close down all this, so offer nothing, just continue to accept these fees as profit. Do you agree with that?
I don't agree that we could close this down altogether. I mean,
What stops you from doing that?
I think even the club plan would put a limit on the types of changes that can take place.
Show us where, cite to the document that limits it out.
That it would take me a moment, Your Honor, but
I'll tell you what,
Yeah.
we'll start your rebuttal and give you an extra minute if you need it to address that issue. So you-
but that is clearly not the,
That's a question that we have is, what limitations are there in what you can do when you have a profit fee that's built in to run in perpetuity? What limits, I understand you have a schedule and there's limits, but looking at the greater plan that the legislature has set out and restrictions on covenants running with the land, what limits are there that someone could, you all have, I believe it goes up $1 per month, is that correct?
yes, Your Honor.
To a certain point, and then it freezes at 25 years. Could someone put $10 a month, $20 a month as far as an increase and continue it for 50 or 75 years?
The important question here is, does Chapter 720 address that?
Counsel, let me ask you this, is there a count 5 where plaintiffs are challenging the validity of the first perpetual covenant? That count hasn't been addressed by the court at all.
That's correct. It has not been addressed. It's severed. There's a severance order, and the trial court did determine that it was moot because of the determination here of counts 6 and 8. But obviously, if we get this final judgment reversed, I suspect they will want to litigate that as a severed matter.
But the trial court in this case
Did not.
Summary judgment has not made any factual finding on the special covenant at all.
Correct.
But that's really not even what
It's not a legal error that we've raised. I mean, I think I can use it as an explanation for why this is not a Chapter 720 situation at all. And to go back, Judge Stargell, limits would be contractual. There are all kinds of ways you could approach why something is unfair with a developer, but just because you have a problem with the club plan or you think it's overbearing, first of all,
I didn't use the word overbearing. Nobody said
No,
that.
I-
I'm asking is the limitations. And if the answer is no, then that's fine.
in Chapter
You're
7,
saying-
in Chapter 720, no,
In Chapter 720.
for a developer.
For the developer, they can do anything because it's commercial.
It's commercial and it's a privately,
What if it was industrial? Same thing?
I think same thing.
Because it says commercial or industrial, right? So you could operate a factory and say, we want these people to have, to pay us a profit because we're going to run this factory. We think that it's maybe providing jobs to the community. It's important for us to build that in to run with the land, and that would be permissible.
I'm trying to think through that hypothetical, but this is not based solely on the fact that it is commercial. We
Actually,
clearly-
I'd like you to address the hypothetical.
I will address, yes, Your Honor, but this is not based solely on the fact that it's commercial property. It's that it's not even encompassed in Chapter 720. So yes, if there were some reason that the developer also had an industrial property, because remember, the way you get the relationship at first between a resident and the developer is through a fully disclosed club plan where there's actual agreement to the terms and they're set out schedules. So I assume the hypothetical is that a developer is going to open an industrial plant and indicate that that industrial plant provides benefit to residents that decide when they learn about this, when they come and look, they see the industrial plant or they're told about the industrial plant and they decide that, wow, that is an amenity or that is a feature of this development that would make me want to move here. And so I understand I'm going to have to pay for that industrial plant to be there, but I agree to do that. If that purchase sale agreement is signed and if a deed indicates that there is this industrial plant that has a covenant running with the land, that is a choice that a resident made, and Chapter 720 has nothing to say about that. It's not a homeowners association assessment. It's a separate contract when the resident
Enforced by the HOA as an assessment, was it not?
enforced by meaning
Well,
collected.
it was collected by the HOA. It went out as assessments.
Right, but the developer could have brought in,
I don't know. I don't care what the developer could have done. I care what the developer did.
the HOA assists in collections under the plan here, assists in the collections, but that's not because it had to be that way or because the covenant running with the land requires that.
Do you think that there's any meaningful distinction, if there's any distinction at all, between an amenity and an assessment?
Yes, I think the legislature, the definition section
Right.
defines assessment and amenity fee the same way.
Right. And if the legislature wanted them defined separately, they could easily have done that, right?
They could have defined it differently,
And
but
did
I don't
not.
know why they would have needed to do that because then they treat them differently in the rest of the statute.
That'd be in
3086 and 308. 308 doesn't mention amenity fees. 3086 does. 3086.
Is there anywhere else in Chapter 720 where amenity fee is other than you're aware of?
I would have to answer it with that caveat that I'm aware of, but other than the definition and 3086.
Assessment is scattered all through chapters.
Right. And assessment in 308, I'd like to turn to 308 because this is where I really believe this case is trying to put a square peg into a round hole. What is limited in 308? And there are two major leaps, I think, that the plaintiffs make here. And I think this case falls apart on each of those two major leaps. The first is the crux of the plaintiff's argument really comes down to 308 as to why these private membership fees would be subject to Chapter 720 at all. And in 308, the key language says that assessments that are levied pursuant to the annual budget. There's only one annual budget mentioned in Chapter 720. And in order for this to apply to the club membership fee, you would have to assume that the annual budget that the legislature in plain language mentions actually means any or an annual budget, and reach outside of what the purpose of the statute is, which is to regulate homeowners associations, to reach out to a developer's annual budget for a private commercial entity. What 308 is trying to limit is assessments that are levied pursuant to the annual budget of the association, which is defined, the annual budget of the association is defined in Chapter 720. No other annual budget is defined. And so this section clearly is aiming at assessments by the homeowners association on the residents. And the plaintiffs also, and this goes hand in glove with the argument I just made, the plaintiffs also rely on subsection 3 of 308 for the same basic argument, which is these assessments are governed by this limitation in 308. But subsection 3 is talking about a guarantee. If you look at subsection 2, subsection 3, and subsection 4, they all are on the premise that the developer has chosen to give a guarantee. There is no guarantee in this case. The developer did not use that option that a developer can do in the declaration. So off the bat, subsection 3 really doesn't apply to the facts of this case. But what is really telling is subsection 3 does reference the adopted budget, again, which necessarily must be the association budget because it's the only budget.
Let's talk about the fee budget plan. You saying that there would be a scenario then that housing development that has multiple, tens of thousands of homes, I think this one has 45,000, couldn't have multiple types of associations and entities that were running two different budgets that were assessed on the same building somehow? Because the fee budget that all has to be combined into one.
Yes, Your Honor.
The legislature said fee.
Well, I'm saying that what the legislature anticipates for the homeowners association is that the homeowners association will have the annual budget. Section 303 sub 6 defines the annual budget. So the homeowners association needs to prepare the annual budget every year.
But your assessments are separate and apart because that's profit and that's running in a whole different way.
Right. It's not even subject to 720. We prepare.
Except all of the assessments were done through the HOA.
The HOA effectuated them, but in the documents, in the club plan, it's clear that it's a separate obligation.
Whatever the plan was, you utilized 720 to collect this profit, correct?
I have to answer that again with the fact that, yes, the documents reference 720, but it was an error for the attorney to do that. And that's unrebutted in the record. The bottom line, Your Honor, is it did not have to be done that way.
But it was. Whether it had to be done or not, it was done that way.
But that doesn't make a difference as to legally how you interpret this statute, because legally this setup is not dependent on Chapter 720.
Okay, but you all then want the benefits of 720 without any of the restrictions of it.
I don't think we need any benefits of I don't understand what benefits. Our attorney mistakenly cited it, but we didn't need
That's
720.
It's awfully convenient to take that position, isn't it?
Your Honor, we had a right under the covenant running with the land to foreclose. Those documents didn't need to reference Chapter 720 at all.
But they did.
It was a Scrivener's. I understand, Your Honor, but we're here on how does this statute.
Wasn't there evidence in the record that different bills or invoices were sent, one from the club, we'll call it, and one from the association, but maybe sent through one management company for both?
No, that's absolutely true. I mean, the bills are separate. Yes, and
Are they separate line items or separate bills?
I believe separate line items, but I can check that at my break.
You can start, we'll give you another minute.
But clearly they were delineated as a difference. And so, you know, it is clear that they were separate and distinct when the residents received them. We do have this issue that, yes, I don't think there's any confusion as to where these different line items are coming from. I don't think anybody was confused that the homeowners association was charging the membership fee or the expenses for the club. I don't think that's even an issue in this case.
Now, the developer could get the debt service paid. He can get profit by the management of the club. He could charge a user fee if he desired. So there were a number of ways for the developer to make profit on these facilities, was there not?
There are ways to make profit vis-a-vis third parties. This ruling in this case precludes the developer from making any profit.
I don't think it does that, though. It depends on the definition of expenses. And under the definition of expenses, the developer can include a whole range of items within expenses, including some that would be profit.
I think that the theory of the case on the plaintiff's side is that the expenses are limited to the hard costs, which they paint as being very broad as set out in the club plan.
Can the cost include a management fee?
I think that's where they say no. And that's where,
Well, this isn't a management fee. You know, what's being fought over here, it's got nothing to do with a management fee. It has to do with the sole characterization is profit. And they make it very clear. This is pure profit. Got nothing to do with managing it, with running it, with the debt service on the facilities. That's really what the argument's about, is it not?
I think what the argument is about is in the club plan, there are, because of the labeling that was used at the time the club plan document was written, with no foresight that this type of argument to try to force this into Chapter 720 would come about. There's one item that's called club expenses, and that does capture a good amount of. Then there's the club membership fee. They are clearly two different components of the overall cost to the resident to have this facility. And the club membership fee can be thought of as profit. It can be thought of as a fee for a non-exclusive license. But in the document, it is crystal clear that there are two components that make up the total expense to a resident. So from the resident's point of view, the expense of having access to these facilities was disclosed from the very outset as having two components. And what the plaintiff's theory is you are only able to pass through what you labeled as expenses, not the component that would represent a non-exclusive license or profit, if you will. You can't pass it through. But if there was a landscaper, for instance, who sent a bill to a landscaper for the association, sent a bill to the association that had the hard costs of providing landscaping, plus the profit to the landscaping company for providing the service. And the association turned around and passed all of that through to the residents. The residents couldn't say we would only be obligated to pay the expense portion. They would obviously have to pay the entire expense to the landscaping company, even though the landscaping company is making a profit.
But when the developer sells a lot in Solavita, isn't the recreational facility part and parcel included or factored into the price of the lot and the price of the construction? And isn't that what draws people to somewhere like Solavita, just as Del Webb puts out these types of nice facilities where they have restaurants, they have clubs, health clubs, and all different kinds of events that go on. Isn't that part of the draw? And isn't that factored into what people pay when they buy a lot and build a house in Solavita?
I think that actually would help me, Your Honor, rather than the plaintiff's theory. But yes, I think.
Well, then you're welcome.
What's that?
You're welcome.
I think that underscores why people would agree with full disclosure to pay a membership fee. I can't say for sure, I don't have the empirical evidence as to what it does to the actual outset price to buy into the community. But I definitely think the fact that somebody would look at a membership fee and agree that, well, that makes sense, it's scheduled, I see that it's
Do you
scheduled.
think they'd anticipate that they would have to pay for a $50 million bond or whatever the amount of the attempt to bond out and get out of this? You think they anticipated that?
I can't say whether they anticipated bond, but I think that they anticipated that this was a perpetual covenant. That's what it says in the club plan. The club plan also says that the developer will make a substantial profit in accord with the substantial investment that's been made. I do, before I sit down, and I know I'm out of time, I really need to emphasize that our affirmative defenses were decided as a matter of law. This is clearly a case at a minimum of voluntary payment, and there at a minimum are factual issues in the voluntary payment doctrine, which is alive and well in Florida, and that was brushed aside as a matter of law. Our defenses were stricken before we could try those. And so I think the voluntary payment doctrine at a minimum, as well as the outright waivers, are an additional reason to reverse this judgment.
Before you sit down, you agree, though, that Judge Smith's earlier rulings are subject to being looked at by a successor judge?
They are clearly interlocutory. My issue there would be that on certain of the rulings, they never were at least expressly looked at. They were just ignored. I mean, they were partial final judgment, partial summary judgment rulings, and they weren't vacated expressly. I mean, you could say that maybe implicitly they were disregarded, but they were never expressly vacated. And so I think they still carry, some weight, but clearly they are interlocutory and they could be overruled.
Thank
It shows you have 324. I'll give you a couple extra minutes for those other issues.
Okay.
You recognize that?
Good morning, Your Honors. May it please the court. My name is Krista Norris. I'm here with Stuart Markman of Kynes, Markman, and Fellman, and we represent the Solavita residents. I'm going to start with the jurisdiction question that you raised. I'm sorry, Kristen Norse, horse with an N. Viking god, I want to start with the jurisdiction question that was raised because I do think it's an important one. And as my colleague mentioned, we did have some discussions about this. So the severed counts fall into two categories. One is the counts that were not certified, and so will only proceed as individual claims. And so this judgment acts on the class claims that were certified and can go forward for the whole class. So it resolves the claims as to the Solavita residents generally. just not those severed individual claims that weren't certified. The other two claims are the voting rights claim, and the voting rights claim is really a different and severable transaction and occurrence. It has nothing to do with the validity of the club membership fee. So that was severed. And there was also the discussion that that really wasn't right because voting rights were only alleged to have come into play after turnover. So severable facts, arguments, transaction and occurrence.
So let me ask you this in terms of, so it sounds like I'm hearing you say that the partial final judgment of the other
Yes.
claim has been severed or independent or not interdependent.
Right.
How can they be not interdependent when every single count incorporates like 79 allegations?
So may I ask you if you're referring to the, are you worried about the individual claims or just the counts 2 and 5, which are just the class claims?
Say I'm worried, I
Okay.
have a question
Okay.
about both,
About both,
but let's talk
Okay.
about just the class claim.
the class
That
claims,
is
right,
count 2, count 5.
Right.
They're certified,
correct.
but then severed, and as Judge Cohen pointed out, not dismissed.
Mhm.
They're still there, alive
Right.
and well, stay.
Right.
And so those claims, they incorporate, look at all the counts,
Mhm.
all incorporate at least 79 allegations,
Mhm.
common allegations,
Mhm.
all into each other. And then there's a few that they try to quote the number, but like
Right.
they're referencing to the two, for example.
Mhm. Mhm.
So how are
Right.
they to all independent?
I think count 2 is not interdependent because again, it relates only to the voting rights that would be afforded on turnover. So I don't think that those are interrelated to the validity of the club membership. You don't have to, we're interpreting different provisions. We're interpreting different facts and transactions related to just the collection of the club membership fee here. So in that respect, I think count 2 is appropriately severed as a separate cause of action involving a different transaction occurrence. As to count 5, and as to count 5 was an alternative request for relief. And so the judge ruled that it was effectively moot. So count 5 asked the court to determine that a perpetual fee would be terminable at the perpetual fee would be terminable at will. And it was an alternative request for relief. So count 5 only reactivates if the court reverses that the club membership fee cannot be collected in the first place. Then the question arises as to whether it was.
Both you and your opposing counsel are using in different ways this issue that's been raised by all of us in terms of the perpetuity of this covenant.
Mhm.
And so how is that not interdependent with the claims that are before us now, because some of the concerns and questions of the fact that this, I agree, the court clearly has not said it is a valid perpetual covenant or it's not.
Mhm.
That's an issue that remains to be decided. That's key to these other arguments, or at least not interdependent.
I don't think it is as to,
Pause for,
Yeah.
yeah, 1 moment.
We're just going to take a water break.
Yeah.
It's always important that everyone knows. Hydrated.
We're just going to see if we can do something about the,
Someday we'll have
yeah.
they started earlier and I wondered if I would be competing with them. So
You'll have plenty of time to.
that's fine. That's fine. I understand.
We agreed as I said ahead of time. Because there's only 2 days to stay.
Up all day.
We don't want to get lunch too early. Plenty of time.
I think the presiding judge usually buys lunch. I can come up with a rule for anything.
There's a buy one, get one for a buck at McDonald's. I saw it last
Good
night.
enough.
All right.
Okay.
So As to count two, I would say that does not depend on the validity of the perpetual covenant, because again, that's the voting rights that they
Go
would
to
have
five. Let's
on
go.
turnover.
Focus on 5.
Count 5, again, I think the reason that it doesn't affect your jurisdiction here is because it was an alternative. And so I do think that the narrow ruling here is the club membership fee is invalid for violating section 720.308. If that stands, count 5 is done. There's no relief in count 5 that is necessary because we don't need to allege that it's terminable at will if it was never valid in the first place. So I think that's why you continue to have jurisdiction despite count 5. And then again, as the court has pointed out, because again, count 5 is moot if this ruling stands. So it's like a judge deciding I'm not going to decide relief B, I'm only deciding relief A, that solves the case. That's what count 5 is basically.
I wouldn't have this question if after the court says it's moot and therefore it's dismissed, but the court didn't do. It says it's moot, but doesn't dismiss it, that stays it. And so it sounds to me like count 5 is dependent on count 6, and that we're going to pursue it if for some reason we don't get count 6.
Which would be permissible anyways in an appeal when the judge decides relief on one and I don't need to decide on the other.
I'm not saying
So,
it's
right.
impermissible.
Right.
What I'm saying is by making that strategic decision to stay, that divestment of jurisdiction takes outside of the timeline 110.
I do not think that it does, again, because it was clear in the order that it was an alternative relief and that it does not survive an affirmance by the court. It's only there, and again, maybe inartfully way for the judge to kind of preserve that he wasn't deciding that issue, but I think it still allows you to have jurisdiction. And as the court has noted, obviously you have jurisdiction over the injunction and all of the legal issues are the same. So I think effectively, this court decides the validity of the club membership fee, and that resolves this issue, the validity of the club membership fee, this transaction occurrence as the club membership fee as a final matter.
All right, let's talk a little bit about 720. And
Yes.
do we start with an apparent agreement between the two parties that this is commercial property or not?
We don't actually believe it's commercial property, but that does not need to be decided to resolve the case.
Is that the initial documents to disclose it when they went to Polk County?
Right. I mean, when you look at the structure of these communities, generally the planned developments, you see sort of a subset of 3 different types of property. You see commercial property, you see residential property, and then you have these like non-commercial, non-residential common areas or amenities. So I'm not sure that the ruling that Judge Smith made that this is commercial property necessarily follows, but Judge Durden didn't change that, and that's not really been raised as an issue on appeal. And the reason is because it doesn't matter whether it's commercial property or non-residential property, et cetera. Section 720.302 merely says that a commercial parcel is not subject to the requirements of 720. And that makes sense.
Interpretation means they just don't pay.
Right.
They don't get an invoice, they don't pay.
They can't be assessed.
They're not a member of the homeowners association. They're not supposed to pay the fees that are required for the clubhouse and the pool. They have a separate purpose in the community. So that's what commercial property exception is for.
Do you think that there's a difference between assessment and amenity?
There is not a difference between an assessment and an amenity fee because that is defined under the statute as the same.
Okay. You heard Judge White talk about the use of the phrases assessment and amenity throughout 720.
Correct.
So why don't you address that issue?
Right. And so amenity fee, I think, as you pointed out, is used in 720.3086 specifically. Other places in the statute use the term assessment. But I'd like to talk about 720.3086 because I believe that section actually undermines rather than supports Avatar's argument. Because 720.3086 doesn't say that a developer can charge an assessment or an amenity fee, again, synonymous under the definition provided, in excess of expenses. In fact,
But you're saying it's synonymous, but I'm going to suggest to you that that's up for debate.
okay.
And that's why I want you to address that
Right.
specific issue.
Okay, so the definition of 720.301 for assessment is assessment or amenity fee, both in quotes, means a sum or sums of money payable to the association, to the developer or other owner of common areas, or to recreational facilities and other properties serving the parcels by the owners of one or more parcels as authorized in the governing document, which if not paid becomes a lien against the parcel. So both quote, the quotes around both so that they both are governed by the same definition.
But that same definition, and if I understand Colin's argument, is the person who is charging the assessment of the event fee uses or it says payable to the association, the developer or other owner of common areas, or to recreational facilities and other properties serving the parcel by the owners of one or more of those parcels. And so understanding, respond to Colin's argument that, if I'm understanding it, that assessment comes from a homeowners association and like the various steps, where the amenity fee comes from a different entity other than the association, specifically either the developer or an owner of recreational facilities or other properties serving the parcel.
Okay, I'm going to try to make sure that I understand your question. So I think when you look at that definition, you're right, it has or. It has or twice. It's assessment or amenity fee. And then it has the entities to which those can be paid, three separate entities. And so if you look at that, so we have assessment or amenity fee means these things paid to one of these three potential types. And the others, I'm kind of gathering together, other owners of properties serving the residential units. So then you look, well, so what are the limitations on this? And those limitations are in 720.308, which is entitled specifically assessments, and then places limitations, not isolated.
Other than 0.301 of 1, 0.3086, amenity fee used anywhere else?
Not that I know of. I don't believe it's used anywhere else. But again, in 701.1, they're defined as synonymous between, amenity fee could be paid to an association. Amenity fee could be paid to another owner. Assessment can be paid to association or another owner. And so I don't know how you give effect.
To assessment,
Mm-hmm.
is there any location where the term amenity fee is being used as being able to be assessed or charged by the association?
I mean, the definition itself says an amenity fee can be charged by an association.
But implying the whole text canon
Right.
to the full statute as full. Isn't it true that assessments throughout chapter 720 is almost always used in conjunction within the same subsection, some subparagraph or somewhere, the word association?
No, I don't believe that's true.
Okay.
And that's because of 720.308, because that limitation of an assessment by an association is not in there. So if you go to section
In that one specific part about the
in two parts, right, in two parts when we deal with assessments. So we define assessments and amenity fee as synonymous, and then we have a provision that deals with assessments. And yes, we have another provision that deals with amenity fees. But if the two are synonymous, you should be able to mix and match those two terms. There's nothing that in the whole text of the statute that prohibits that.
Well,
So I do,
in
right.
sub 1, where it starts out as 0.308 assessments,
Mhm.
for any community, when you look at the definition of community in 0.301, which pieces together together a bunch of other depositions, doesn't it ultimately require to be talking about those parcels where membership in the association is required?
When you read so the definition of community, and I'm glad you took me there, because I do think the beginning of 7.2.0.3081 starts very broadly for any community. And so what, after 1995, this is after 1995. So what is a community? Real property that is or will be subject to a declaration of covenants, which is recorded in the county where the property is located, includes all real property, undeveloped phases, subject to impacts, etc. So there's nothing in community. That's 720.3013. So community is basically any property governed by the governing documents. So yes, when Avatar decided we're going to use governing documents to govern these residential parcels, then it is bound by 720.3081. And so now assessments.
But how would you respond to point out real property?
Right.
Your argument and challenge to the opposing counsel about commercial parcels is, well, that only applies to the real property. Here it says community means the real property. So if real property has been excluded under all of Chapter 720 because it's commercial, then how does that fall in the definition?
So I think we're mixing to a certain extent again, the commercial parcel exception says the parcel that is commercial is not subject to these other provisions. But it doesn't say that the developer, just because they happen to hold commercial property or industrial property, is somehow not subject to other restrictions that apply in this section. So,
well, I think it's beyond dispute. I'm certainly not hearing your opposing counsel argue that the developer owns residential parcels.
right.
That is, that's clearly
Right.
the purpose of 720.
Right.
As Judge Starkey mentioned, that's the whole turnover situation.
Right.
But but following up on that, I mean, there's a bank and a pharmacy here.
Right.
They're commercial.
Right.
No disputes that.
Right.
Would you believe under the statute that they could charge any fees at all based on that bank?
Right. No, and I think that's
Run that with the land?
right. I think that's the issue, is that the fact that you own a commercial property as a developer, as an owner, doesn't allow you to then assess the residential properties. That's what we're talking about here, the limitation on assessments. Assessments can be paid to 3 types of people. None of those types of people can have an assessment that violates 720.308. And that's how broadly 720.308 is written. So we start not only with the community, it's any community after 1995, subject to 720.3081. And then we have the definition of assessments, again, lien enforceable payments paid to one of these 3 entities. And then we have, and by the way, it's not been disputed that the club membership fee is an assessment. It was never called an amenity fee. The bills did go out separately, but they were called assessments on the bills. It's always been labeled as an assessment. The club plan is not independent from the master document. It's incorporated into the master document, and under the section in the master document that talks about assessments are the club dues. So this was an assessment by Avatar's own doing. So having an assessment, being a developer, taking advantage of 720 to govern and allow this lien enforceable payments, they had to comply with 720.308.
Under your theory, a developer is going to put in, these very nice recreational centers and tennis courts and these things called pickleball courts. And
You'll be learning about this.
I will soon. And at that point, why can't a developer earn a profit off of those things? And under your theory, how does a developer obtain, a profit or even repayment on the investment that they've made putting in these types of facilities?
So they can earn a profit, and in fact, Avatar does earn a profit even without the club membership fee. And that is because the club plan calls for non-assessment revenue that they can earn. And they can earn it like any other business does by offering a good or a service that people want to buy. What they can't do is they can't guarantee that profit by a lien enforceable assessment on the homes. That's what
Does that
720.3
suggest
is.
that people are going to buy in a subdivision like Solivate and then have to be charged to go into for the use of these facilities? Is that really what happens?
I don't know that that's what happens. I think what happens generally, first of all, this is the only, development that was pointed to as to this type of, the extent of this scheme. But
Well, not on the amicus. The amicus seems to suggest otherwise.
right, but the evidence below was they did not produce any specific club plan that was precisely
Yeah, of course,
like this one.
one of the amicus briefs also says this case is simple, which was very helpful.
So there's a few ways there's lots of things the developer can do. One, they can charge more for the homes because of the amenities that are around it, right? They can have the homeowners association own the amenities, and then they can charge the homeowners association through voting, accessible, community members engagement. They can charge the homeowners association for fees and costs that they want to provide to the homeowners association. They do get an additional increase in value because of the amenities. In fact, their own paperwork told the residents that this was a single product, that they were, this was important, that they were getting these amenities, and yet they actually, were not going to have any say in the amenities whatsoever. And there is no limitation in the club document as to what they could do. The limitation in the club document is non-existent. It says that they can remove properties, they can add properties, they can decide not to run the club whatsoever, and yet the club membership fee would remain due and payable.
Correct that you all do not believe that they could throw a management fee in there to cover overhead or the other costs?
What they actually have a provision in that expenses includes a portion of their administrative expenses for Avatar's administrative expenses. So they can, in fact, cover every conceivable expense, debt service, all the costs of operating this property.
But not profit.
But they can't assess the profit.
Not even profit within the expense category.
I don't see, I don't see a way that they can do it consistent with 720.308. There are, and I think this is the more common, that the association owns the amenities and then the developer provides services for a profit to the association. I think that's permissible. I think there's a lot of ways you could do this, but you can't do it the way they did it.
If this is a covenant that runs with the land, couldn't they have enforced this other than going through 720?
I don't know that they could because of the language in 720 that now a community is anything governed by a governing document. None of the cases they cite are post-declaration, the 1995 declarations. And so 720 now covers any community, which is any property governed by the governing document.
But doesn't the definition of declaration require that the property covered mandatory membership in the association, which that's not the case here. The club doesn't. I know that so we have developer as owner of residential lot, clearly subject to association.
Correct.
But we're talking about commercial property, not homes, not residential parcels. Going back to 301, under declarations, at the end it says control of the association or association in which the owners of the parcel or their association representatives must be members.
And again, the fact that you own commercial property doesn't then allow you to do an assessment. You can only do an assessment if you're a developer or an amenity owner who wants to assess expenses. And 720.308, when it talks about assessments, it says this is the way we share expenses. The governing documents must describe the manner in which expenses are shared. And so every discussion of assessment in 720.308 is it's your share of expenses. That is how it's defined in 720.308 and as set there. And so the fact that you own commercial property does not mean, I mean, that interpretation would mean anybody who owned commercial property could potentially charge assessments, but you can't charge assessments under 720.308 unless you are also a developer, unless you're also putting that commercial property out for the use of the members. So we all still come back to what is an assessment? What is an amenity fee? And I do want to quickly touch on the 720.3086.
Well, before you do that, I don't want to follow you into that good night, but I'm trying out to do more hypothetical.
Okay.
So if in this case, take the same document, essentially, tweak it so that instead of charging the owners, the documents say that the association shall pay. And they lay out a schedule for each residential parcel. Okay, say the fee will be this, we will determine it based on our budget, and then these are all the subject parcels, and every year we're going to send this bill to the association, and we're going to tell you, here's what the charge is going to be, the fee or charge. This is what it's going to be. And of course, since it's a for-profit corporation, that's going to include a profit. Do you agree with that?
I agree. I agree.
And so then, under 720.303 sub 6A, wouldn't the association then, although be required to set up separately all fees or charges paid by the association, recreational event, whether owned by the association, the developer, or another person? So it's got to be set up separately, but that's going to be part of their budget, and that's going to be passed on at the time to the homeowners, including a profit, with an assessment, and if you don't pay it, there's no fee at all.
And I think that is permissible under 720. I think that is permissible because it's through the association. And so if you are going
So
to,
because they did it directly, even though the result is exactly the same, that's the reason why it violates?
it's not exactly the same because, and by the way, there's other provisions and protections in 720 about provisions being reasonable and things like that, but we don't need to go there. But the whole structure recognizes the developer controls the association in the early days, right? And so the developer can have services that it's going to provide to the association, and then the members ultimately will gain control over those and be able to cancel those if they don't want to do that, right? If the members, now the members become voting. Okay.
So my hypothetical is, what plan is reported, then the declaration gets on top of that, what plans that exhibit, everything's the same except basically
The association pays.
what the owners learn is, if I buy into this community, my association, of which I have to be a member, and then assess these costs, this is what I'm going to have to pay. I'm not going to be responsible for paying it directly to the club owner, but I am going to be responsible to the association, and for purposes of my hypothetical, it can't be changed.
But I think that, again, the important difference in your hypothetical than the difference here is it is through the association, and the association is a member-driven entity, originally controlled by the developer, but ultimately the members retain the right to change those assessments, to decide we're not going to have that in the budget. We're not going to pay the developer.
But how would they be able to change it?
They may not while they don't have enough voting power, but when they have enough voting power, they will be able to change it. But that is the system that this, that.
If the land sits underlying the holding just like here, it would be a permanent part then.
So you, okay, so maybe I didn't understand your hypothetical. Your hypothetical is that the charge to the association is not modifiable, even though it's part of a budget.
Correct.
I don't know that you could do that.
It's a
You can have,
It's a fee or charge paid pursuant to the reported documents. It goes to the association, and then under 6 of A, the association has to lay it out.
But if it's
Here's
in-
what we're paying.
I guess what I'm not understanding is if it's in sub 6, if we're talking about 3036, that talks about the association's budget. So to me, if it's in the association's budget, then the association has control over what is in its budget, and the association is then governed by the members at some point in time.
The
So-
association may pay garbage expenses from a governmental entity. They don't have control over that.
They may not have control over that, but I think one of the cases exactly was on this point. It was a condominium association, and there was a mandatory fee, and it was decided by the association when the association gained control by the members, they weren't going to pay the fee anymore. They modified the documents.
Because the document permitted.
The documents permitted modification, but I also think again, it depends. Are you talking about something that's in a budget, or are you talking about something that seems irreconcilable? But, the assessment under this, if it's paid to you, it's paid to you to cover your expenses and only your expenses. And to work in these other options, like, well, you can define expenses to include profit, or you can say that, this doesn't apply if it's a developer or if it's amenity owner, then the protection on the limitation is effectively meaningless. It's only, in fact, the association is the one entity that gives the homeowners some protection because they have a voice, because they have voting. And I also want to talk about like 720.3081. Okay, so let me talk about that. Right. So what's 720.3086 requires is a reporting requirement. And what does it require the developer or amenity owner to provide the homeowners? Every single homeowner has to be provided a report that accounts for assessments and the expenses paid with them. 720.3086 is exactly an enforcement mechanism or an assurance mechanism for 720.308. There's no other way to read it. And that actually aligns with some of what the association has to do.
Somebody else, that their expenses and their fees must.
It doesn't say that, but but what would be the reason for them to provide a report? If the homeowners could do nothing about it, what would be the reason for that financial report? There has to be some reason for that report, or else that statute is entirely superfluous. And it's similar to what the association.
Are there regulations of corporations throughout? We're a capitalist economy. Isn't there reporting requirements just for the purposes of reporting, so that people can see things and maybe take political action, maybe to change something?
But under this scenario, there is no political action to take. They've made it a covenant running with the land. There's nothing that they can do about it. That's their position. It doesn't apply to them. So they can, and they didn't comply with this, by the way. But the financial report is to report to the homeowners about expenses and assessments. And that plays right into 720.308. Amenity fees, again, defined equally as assessments. And this goes right into 720.308. And the reason is there's actually a parallel here. So the association, and yes, this chapter talks about associations. The association is wholly a creature of this statute. So there's no need to talk about budgets of developers or budgets of amenity owners, only as they relate to what they have to do to these communities, right? So we go to 720.3086 and it says you have to provide this report. Well, that aligns with something that the homeowners association has to do. The homeowners association has a two-step process. They do the budget. That's the prospective guess of what the expenses will be. And then they prepare their assessments accordingly. The developer can do that through their own budget. At the end of the year, the association is also required to provide this very same financial report. What did you get in assessments? What did you pay in expenses? So there's an alignment here between 3086 and that reporting requirement. The legislature is not regulating how they set their whole budget, but it is as to the assessments and the expenses paid with those assessments, that is a reporting requirement. It aligns directly with the association, which makes sense since assessments can be received either by the amenity owner or the developer or the association. So everything fits together to say 720.308 means what it says. It says assessments set by the budget or special assessments have to be in a proportionate share of expenses. I do want to point also to the one other piece of my past time. You've given us. Okay. Okay.
Add some time for you. I'd like you to address the affirmative defense.
Sure. Yes. Okay. Let me turn to those. So the affirmative defenses are two. One is that the release provision can basically prevent any resident from ever challenging the club membership fee. And we've discussed a case law that's very consistent that you cannot contract to violate a statutory prohibition. And I think the Gables case that we discussed probably explains that most. Judge Luck, then Justice Luck, now Judge Luck again, explained you have kind of two categories of cases. You have a case where there's express statutory prohibition, and if it's prohibited, you cannot contract around it. Then we have, it's not really prohibited. We don't know if they meant to prohibit it. And so in that case, then we're more concerned about the right to contract. But where the legislature has included a prohibition, that is the public policy. There is no need to guess at it. Violating that is non-enforceable. And here, of course, the club membership fee and the attempt to prevent anyone who is actually bound by it from contesting it would basically contract around the prohibition. A voluntary payment defense, it's never been applied after a statutory abrogation, absent two circumstances. One is payment of a governmental tax or fine without protest, and a defense to an equitable claim for money received by imposition. You will not find, and I have definitely can say this, I have checked every mention of the voluntary payment defense. Those are the only two scenarios in which it applies, neither of which apply here. And in addition, under that defense, there's case law saying that the threat of a lien and enforcement and penalties is enough to make the payment not voluntary. And then third, on the voluntary payment defense, that's an equitable defense, does not protect you from a statutory violation.
The procedure in which the trial judge made these rulings.
Mm-hmm. I think the procedure in which he made the rulings just sort of followed from the way the case developed. So early on with Judge Smith, you know,
a rule of civil procedure that that you're citing for that proposition?
No rule of civil procedure, just you know, the rule of how cases develop.
Okay.
So originally there was some potential disputes over, was this really an assessment? I think that's what Judge Smith was worried about. How was it billed? And but towards the end, when they were getting ready for trial, and there was a lot of discussion about what are we trying? What is the jury going to decide in this case? Then Avatar at that point said the validity of the club membership fee under Chapter 720 is effectively will resolve the case, and that's what happened. And then the affirmative defenses were then addressed, I think, at that point.
Yeah, I know, obviously, go ahead and say it. I know both sides have done an excellent job in bringing all the issues before the court. And I know the parties disagree about the meaning of this statute. But in terms of the waiver estoppel application, under the circumstances of this case, where you have 308, you have assessment, you have amendment, you have 308, your argument, and then you have 0.3086, we talked about amendment and be children. And then you have commercial property. Parties disagree about the extent of what is excluded. Taking all that into account, doesn't that make this case different than the other cases where it is a clear, unequivocal prohibition that really no one but someone unreasonable could say it's not prohibited? Where you have something like this, it's the kind of case where, you know what, it's not going to be stricken as a matter of law. Can't be good. Can't be a state. Can't voluntarily.
I don't think that the case law supports that, because the case law that allows waiver only allows it when it's not a prohibition. So if you find that this statute prohibits what they did, then I don't see any support in the case law for deciding, well, we'll let it go because of a statutory provision that said nobody could challenge it. I did not find any case like that. The cases that they're citing all, in fact, AHF in particular says there was no prohibition. So I don't think it matters whether you think maybe the prohibition wasn't exactly clear, et cetera. And also I would point out that Avatar, you know, it's not like Avatar went into this with their eyes shut, because that provision actually suggests that they themselves thought maybe this was not legal. And so having some lawyer, you know, trying to impose on the residents, well, you have to get some lawyer to just tell you that this is legal, and you say that it is legal. So they didn't go into this with their eyes shut. They knew they were pushing at least the limit, if not crossing it. And I think the statute is clear.
Say that's similar to the circumstances that love the analogy that just as the fact of disclosing a sale of heroin, making a disclosure doesn't allow him to waive it. If we're not talking about sale of heroin, clearly prohibited by the criminal law subject to incarceration and imprisonment. These are very good lawyers disagreeing on the meaning of these statutes. Second, what they mean to the extent of the prohibition. So, again, the purpose of my question, let's assume it does. Setting aside the affirmative defenses, it is a violation of 308, but because of these other purposes, 0.3086, the failure to specifically prohibit the statute where the legislature says we're going to prohibit these particular ways. All of that taken together.
Again,
Law,
I think as a matter of law, if this is a prohibition and they have crossed the prohibition as interpreted by the court, then the law does not support giving them the right to just sort of waive it. And that, in fact, holding that would only encourage more of these types of provisions, more pressing the line, more seeing if we can get close and say, well, we were confused about it. You know, assessments are defined. They use Chapter 720. They constantly avail themselves of it. And assessments are defined by the relative share of expenses. And so I think if there was confusion, it was at least they knew it was a close call, but the law doesn't say that, well, if maybe you got it wrong, that's okay. The law says if you run afoul of a prohibition, then you're responsible for that.
A lot of ground to cover, and I'll. Okay, and I want to be helpful to the court, so if I'm going down a path that you want to change it, please do. But to answer the two lingering questions from my first time up here, Section 19 of the club plan, which is on record, well, I'm sure it's 5 times in the record, but the one I have is 22007, and that speaks of, you know, if the facilities are destroyed, what the club would do as to membership fees. Short of that, there is flexibility, obviously, in the club plan to change the facilities, but whatever remedy, that's not an issue here. There's no argument that we have charged the membership fee and haven't provided premium facilities. So that's not in this case. But if that arose in some other case, the remedy is not to find a remedy in Chapter 720 that's, you know, applicable to all developers when the chapter itself is not. The remedy would be some other type of cause of action that you're enforcing a club plan that is being handled unreasonably. It's not this type of case. And so the hypothetical, I think, assumes that this would be the answer to that problem. And that's not a problem in this case. And if it ever became a problem, a remedy would not be this. It would be a different remedy. I really need to clear up though, just to make sure we're talking on the same page. The homeowners association is not sending these invoices or foreclosing. There's a management company that's being used, but the management company sends the invoices for both the homeowners association and for the developer. They're two different invoices.
No, I understood that.
Okay, I did not want to leave the impression that the homeowners association is actually somehow.
Yeah. No, I was aware that there's a management company. that sends it out.
Right. And, the issue as to the Scrivener's error is that the foreclosure document cited, chapter 720 when it was unnecessary to do that. That wasn't needed. But
Well,
again,
that's not a
that,
Scrivener's error.
What?
Yeah, Scrivener's error, it isn't different than saying, well, we didn't have to do it this way, we could have done it another way.
it
That's
was,
not a Scrivener's error.
it was a mistake by the foreclosure attorney.
No.
And there's an affidavit that says that. But I want to really emphasize it. It's a handful. This is a gigantic sprawling development. It's a handful of mistakes, just handful of foreclosures. And I don't think that
I'm
mistake.
not, listen, if I were the lawyer, that's probably the way that I would have gone about it, because that's just a logical and clear way of instituting a foreclosure action. So I'm not critical of the lawyer. I'm more critical of the argument that, oh, this was just, some big mistake.
I'm just citing the affidavit.
I
But-
understand.
But the point I would make is that mistake should not guide this court how to interpret the statute as a general matter. I mean, that's a mistake in this record that has been cleared up with an affidavit, but we're here as to what does this statute mean, not just here, but the status quo across the state is that there are developers doing this, and whether you want to put credence in. Well, there's Exhibit J to the filings repeatedly that has a list of 11 others. But I mean,
Well, counsel, for what it's worth, we are not unaware of the significance of, this case and our decision in the case. We're very well aware of it, which is why I made the comment about, the amicus brief saying it was a simple case. There's nothing simple about this case. And we are acutely aware of it, painfully aware of it. And we'll try to get you an opinion out within a year.
no, I appreciate, I just
But
don't.
you can't retire until that.
What-
I'm gone, buddy.
What I'm emphasizing, I think I've made my point, but I don't want a mistake by a foreclosure attorney to impact.
That's not gonna,
What-
I'm not telling you that it's not necessarily gonna be, part of an analysis. I can't speak for
I
my
understand.
colleagues, but, is that gonna be, the entire basis of an opinion? I doubt it. We haven't written the opinion yet,
Right.
so we don't know exactly how it's gonna read or who's gonna prevail. But I understand the point you're making, but you don't need to belabor it. It's not,
You talk about the affirmative defense of the waiver and the affirmative to do what you've done here, and you'll waive the ability to have any limitations at all.
Okay, as to waiver, I would first start by saying that Judge Lux Gable's case did not even address affirmative waiver. Here you have an affirmative waiver of a statutory protection. I would say not a prohibition. I would say at best a protection. And all of this only arises if, I need to take this in steps. All of this only arises if you don't agree with me that Chapter 720 doesn't apply at all. But if we're into the realm where.
well, that is the nature of an affirmative
Right,
defense.
right. And so if we are in this realm, then a statutory protection has been affirmatively waived with prior to purchase with full disclosure. I don't think there's any bamboozlement or confusion here. And statutory rights can be waived. Constitutional rights can be waived. We cite S&J, we cite Ruggiero.
If the community wanted to say, I know that this 70 mile per hour maximum, the Department of Transportation thinks to cover all roads in Florida, that they're going to waive that for your community, and you can do whatever speed limit you feel necessary.
I think there is a line of authority that an outright prohibition like that. First of all, I think that's preempted. I think that would be preempted. It's an outright prohibition. I don't read this as an outright prohibition. I would say that if you're even to that point, it's a statutory protection. It's not a prohibition, and it clearly can be waived.
So it's a guideline on what can be when you do it. So then you all are in a full separate lane. These are just profits, so we can do what we want to, and it's a commercial use of profit.
And the fact that there would be substantial profits is fully disclosed, no bamboozlement, no confusion. And there's a whole line of waiver cases as to statutory protections and constitutional protections. So this is not extraordinary at all. Voluntary payment doctrine also, I've already talked about that. This was clearly voluntary. And in fact, they have used these facilities. Plaintiffs have used these facilities for years now. And they are seeking, you've seen the number 34 million that's on the face of the judgment, but I should note that pending in the trial court, they have a motion for 27 million in prejudgment interest. We obviously will be contesting that, but I mean, this is a gigantic.
I'm sorry, was that in the record?
It is actually. The filing of it is, I looked to make sure the filing of the motion for prejudgment interest is.
It's not before us. I mean, we understand the magnitude.
Okay, I just want to make sure you don't think I'm going way out. I mean, that filing is in the record on appeal. It's at the very end of.
It's not.
If there is a ruling on it.
Right.
Oh, no,
It's
there's
not,
been
right.
no rule. Right.
Yeah.
I'm just trying to show the magnitude of what has happened here.
As Judge Cohen said, anyone listening to this on TV or in the room doesn't understand. We all understand the magnitude of this, what it can do. The red light's on, but we're going to give you a few minutes because this is your rebuttal time. We'll give you a chance to address issues which your opposing counsel brought up that you want to make sure.
Right. Other than what I've said already, I want to make absolutely clear that the theory that is being proposed for how to read 308 and the limitations of 308 to apply to the club membership fee here means that this developer needs to operate these club facilities at cost. It's not the magnitude of the profits that's at issue here. It's any profit. If the club membership fee was $1, the theory is that it could not be passed along as an expense. And clearly from.
But again, I mean, it's built into, common sense tells you it's built into the cost that people are paying for, the lots and for the construction and in Sola Vita. They're paying a premium for the developer having put these types of facilities in, and that's also what attracts people to these facilities. So he's making, I don't think he's hurting. The developer is probably doing okay financially.
I don't think the record supports that any price differential makes up for the investment-backed expectations, the risk of building these premium club facilities on the expectation of a substantial profit flow, which is disclosed and then being presented with the theory that you can only run these premium facilities at cost as if they are common areas, which we know has already been determined in this case they are not. They are commercial properties and they should be able to be run for a profit, but this ruling precludes running it for a profit, whereas these are two components of the same total price that was disclosed. And to limit you to only being able to pass through what was labeled in the club plan as club expenses, because it wasn't foreseen anybody would ever try to argue that that's the definition of expenses for Chapter 720 purposes. The club plan is very clear. There are two components of the expense of being a member of this club. And one is the club membership fee, one is the quote club expenses. They both are expenses as to the person that's buying a parcel in this development, and they're both fully disclosed. And to carve off artificially the club membership fee and say you can't pass that along because of language in 308, which doesn't even apply to a developer's budget. That's being,
And perhaps had they not tried to, get a 50 million, right, what was the amount of the bond that was proposed? Was it 50? Do you remember?
I don't have the
All
exact.
right, well, it was, a rather large number. Had they not tried to do that, maybe this doesn't come up.
Remember, it's the community development district that brought that bond
Yeah.
validation case. My client did not bring that case. I mean, my client's involved only by the sale, but the CDC is the one that brought the bond validation case.
Okay, thank you.
Okay. I would urge the court to reverse. Obviously, thank you very much for your indulgence for both of us with a lot of time. And I would urge the court to write. Thank you.
Thunder earlier, if I can stand with that. So, did an excellent job on the race. The arguments. Very interesting case, and very much important to a lot of people. So, thank you very much for.
Yeah, well, very well argued on both sides.
Thank you. All right, and with that, let's adjourn.